Okay, welcome to K Talk. I'm Dan O'Gorman. I am Associate Professor at Barry University School of Law.
And I'm Steve Maxwell, Director of Academic Achievement and Lecturer in Law at the University of Miami School of Law. And I'm excited I'm employed this week.
You are. And Steve, I have to mention, last time you said you were between contracts, and I didn't quite get the joke. It was between contracts. It was a contracts joke.
Yes, exactly. Exactly. And speaking of contracts jokes, I think that this podcast is the most promising of all.
Wait, why? Okay, why?
What is a promise?
So meaning, okay,
It's
feel
very
like
promising. It's a bad dad joke. I'm so sorry. It's too early in the podcast for this kind of thing.
See, I was missing it again. So I think what you're going to have to do from this point forward is, if it's pretty clear I haven't gotten the pun, would that count as a pun? I don't even know what the definition of a pun technically is, but if I haven't gotten the pun, feel free just to let me know. You won't hurt my feelings. Okay.
Got it.
All right. Thank you. So yes, this is very promising, because what is a promise? I'll get better at this as we go. It's only episode number 2. So, and lesson number 2 of our Blackletter Law series, where we are talking about, as Steve has already noted, what is a promise? Now, this is a pretty foundational concept. I think this is the kind of concept that it pays dividends later. Steve, is it fair to say you're probably not writing a bar exam essay and having a paragraph on analyzing whether something's a promise? Is that fair to say?
That's absolutely fair. I think this is so foundational, but to be honest with you, it really, I feel like I learned this better once you know contracts. This actually sticks better. I know that's such a weird thing, but as always, focus on the basic definition and you can't go wrong.
Yeah, and I think this does pay dividends down the road when you're learning contracts. And so I do teach this early on in my class, what a promise is, but don't expect to be spending a lot of time probably analyzing, in an essay, is this a promise? But as we do more lessons down the road, you'll see where this issue of what is a promise is going to be relevant. So it's necessary to talk about it and have an idea of what a promise is. And as I like to say, I stole it from a very good book, Understanding Contracts. The law of contracts is the study of the law of broken promises. So contract law is pretty much all about whether a promise has been given and a promise has been broken. And so if you think about it, promises in contracts, promissory estoppel, things we'll talk about, it all sort of comes back to, was a promise given and has a promise been broken? And that's why we talk about what is a promise. Okay, we got a definition, of course, the definition of a promise. And this is a definition that you will find in the Restatement of Contracts. You'll find it adopted by courts. And the definition of a promise is a manifestation to act or refrain from acting in a specified way, so made as to justify a promisee in understanding that a commitment has been made. That sounds awfully legal and dull, Steve, doesn't it?
It does. It does. Is that on the slide?
It is. Wait, yes. Are you not seeing the slide?
I am not.
Oh, you know what? And I blame you.
Because blame me. Was it the share thing?
It's the sharing. We're pausing. It is paused. And so I am going to play. So it's actually working. So now there it is. So thank you for noting that. So there's the definition of promise. It's very kind of long, kind of boring. And I think that the best way to work through promise and to understand it is to break down the concept. And we'll do that. So this definition is long, but if you break it down, it becomes more manageable. And see, that's a lot, isn't it, of learning rules of law, sort of breaking it down to components.
Oh my God, is that ever? That is the key. I think one little phrase, sometimes one word at a time. It just depends on what there's a lot that you don't know early on in contracts. It's another language. And I think students today just sort of blow through things that they don't know, thinking that they'll get it later. And I think that can be really catastrophic in some sense. So I do think that that's the way. As you know, there's usually a case on one little phrase of the definition. Then there's another case on another little phrase. And students just sitting there going, why can't they just put this in a and there it is, the definition, but without the cases to kind of breathe life into each part of that definition. It's like in one ear and out the other.
I agree completely. And that's why I love cases. I love teaching cases. I think students like the case method. I know they hate reading a lot of cases, but I do think the case method, like you said, does breathe life into the rules. And so we'll break it down in this session. We're not going to probably talk about, well, we may allude to some cases, but we're going to try to break it down and make it a little bit more manageable. First off, keep in mind some of the lingo that we use in contract law. So a person who makes a promise is called the promisor, and a person who the promise is made, to whom it is made, is the promisee. Steve, boy, if I could count the number of times in which there is, the OR is somebody doing something, the E is the recipient, right? You see this all the time in law. So get used to that, adding that OR or that EE based upon whether you are the doer or you are the recipient.
It's maddening, but this is kind of an easier one that makes kind of intuitive sense, I think. But yes, this is 1,000 times over across multiple areas of law. You see the or and the E, and it is overwhelming. So learn it as it comes, and it doesn't get so overwhelming.
And I'm going to point something out that we're getting a little ahead of ourselves, but in a typical contract, the parties are exchanging promises. And as we'll talk about down the road, this is known as a bilateral contract. And the thing that's a little tricky there is that each party is both a promisor and a promisee. And so don't think that in your typical contract, there is one promisor and there is one promisee. Each party is both. And that can make things confusing. So the way you figure out which label to use to which party, typically, if they're both promisors and both promisees, is we typically, when we talk in contracts, the promisor is the party who's accused of not keeping their promise, and the promisee is the person who didn't get the performance. So even if, yes, you are a promisor, we might not call you that because you're the one that's pointing the finger at the other guy, and we're focusing on the promise made by the other guy. So keep that in mind, that both parties can be both. But when we say the promisor, we're typically talking about the party who's being accused of not performing. All right. So let's start breaking this down. And I may, kind of bounce back and forth at times. So it's a manifestation to act or refrain from acting in a specified way. I'm actually going to jump over, maybe this is not the best thing. I'm going to jump over manifestation. I want to focus right now on the to act or refrain from acting in a specified way. What this means is that for something to be a promise, it must relate to future conduct. Think about it, to act or refrain from acting in a specified way. So in law, a promise has to relate to some future action. It wouldn't include a representation of a current or past fact. So for example, let's say, Steve, I said to you, I represent to you that the Red Sox won the World Series in 2004. And that would not be a promise. Even if I said, I promise you, you're like, I don't believe it. Are you kidding me? The Red Sox? No, wait, they don't win World Series. I know it's very old school. They didn't used to win World Series. They don't win World Series. I said, no, I promise you, they won it in 2004. That might be a colloquial use of the word promise, the way lay people would use it. But in contract law, that would not fit within the definition of promise, because I'm not indicating to you that I'm going to perform some act in the future. I'm just making a representation of a current or past fact. What that also excludes then is a statement of opinion. An opinion is not about something I'm going to do in the future. In my opinion, the Cubs are the best baseball team. I'm not indicating anything about what I'm going to do in the future. So statement of opinion is out if you look carefully at the definition of promise. And a prediction. I predict the Cubs are going to win the World Series. This is not an indication of anything I'm going to do in the future. So a prediction is also out. And we see, Steve, I know because you teach bar prep and academic success. So I'm sure you spent some time with things like warranties, right?
Yes, those do pop up on exams.
They do, yes. So warranty, a warranty, right? I'm sure as you probably discussed with students, warranties are often distinguished, say, from a mere statement of opinion. So if you think about it, a warranty is sort of like is a promise. I promise to pay you money if this horse isn't sound, something like that. I don't want to get too complicated. But if you're just giving your opinion on something, that's not considered a promise. So that's sort of showing you where this foundational concept of promise, not including things like representations, statement of opinions, mere predictions, are going to be important down the road if a party sues and said, yeah, he breached that promise. And the other guy says, promise? Yeah, I said it, but you took that as a promise. That's not a promise. That was just my opinion, or I was just making a prediction, or I was just telling you something that had happened in the past. So those are excluded under that definition. Now it's got to be manifested. How often, Steve, when you prepare people for the bar, the word manifest, it wouldn't surprise me if that word didn't pop up a lot. Is that a word that you see commonly used to talk about exhibiting outwardly?
It is. I actually teach it under my definition of an offer.
The manifestation. So you're talking about the manifestation of mutual assent, right? Offer and acceptance.
Right. It's, in fact, there was a whole essay that turned on objective theory of contract, which I thought was really interesting because I hadn't seen that, the subject of the whole essay, but it does pop up. Absolutely. And manifesting is the way I think of manifesting is it has to show up to the outside world. The outside world has to see it.
Steve, you've opened up a can of worms. You said objective. Did you say objective theory of contracts, I think?
Yes, and I'm sorry, I hate to objectify contracts. I mean, that could get me canceled.
I see what you did there. Hey, our pilot got picked up. It's exciting.
Oh my God, we're on Netflix, everybody.
We're enough. We went to straight to video. So yes, to manifest is just by outwardly. And Steve mentioned something called the objective theory of contracts, which we will definitely cover in more detail down the road. It's going to be a very important concept in contract law. And Steve is absolutely correct to tie it into this idea of manifesting. What's going to be very, very important in contract law throughout is that we're typically going to assess things, communications, based upon how a reasonable person would construe them based upon what the other person said or did, not what that person, the communicator, intended subjectively in their own minds or didn't disclose. It's what they manifest. So right off the bat, this idea of promise, which sounds all very boring, but embedded within just the mere definition of promise, you've got concepts that are going to be so important down the road, like this so-called objective theory of contracts. Which is to be a promise, when the definition says a manifestation, it means you got to exhibit it outwardly. We care about what people say and what they do. So if you just think to yourself, so in the bubble above my head, I say, I promise Steve X. That is not a promise because I didn't manifest it. It sounds obvious, but it's going to be an important concept down the road. So a manifestation, to act or refrain from acting in a specified way. Note here that a broken promise does not necessarily mean the promiser made a misrepresentation. So students oftentimes think that a broken promise means the party lied. I don't know, do you ever see that, Steve? Do you see any of your students jump to the conclusion that a broken promise necessarily means that the promisor lied?
Yes, and I think they're just throwing everything at the prof, hoping something will stick. And that is not the way to go.
No, you got to be careful what you throw, because yeah, if it's wrong, that can definitely hurt your grade. So I'll never forget where I had told my daughter, yes, I had promised my daughter that I would take her to a theme park. And for some reason I had to cancel. Steve, it was a good reason, right?
Of course. And I'll note that that was about future conduct that you were going to take her.
And I did manifest it. She was aware of it.
You told her, yeah.
That was really my big mistake. I never should have told her. I manifested my intention to take her to a theme park, and then I didn't. And as you know, Steve, come on, I'm a very important man. Things happen, right?
Right, absolutely.
Thank you. And she said to me, Dad, you lied. And I got very angry, very upset with her. I said, how dare you?
Did you cite any cases though?
I was pretty close. I was thinking about it, right? I was ready to go to the study to grab the restatement, but it just, I didn't know how much. She was like 5. I didn't think it would do a lot of good. And so I got very angry, Steve. I said, how dare you? How dare you call me a liar? Now, I wasn't upset that she was calling me a liar per se. I was upset that she was conflating misrepresentation and promise. I said, hey, don't ever talk to me like that again. I broke my promise. I'm a promise breaker. I'm not a liar. Now, she could have been right, but she only would have been right if, when I made the promise, I had no intention of keeping my promise. A misrepresentation.
I didn't know that was the difference. Honestly, that's amazing. Okay, so it has to do with the mental state of the person when they're making the promise. If they're intending to break it, that's a misrepresentation?
Yes. So, like it or not, there's going to be times where state of mind seeps into contract law. We see it a lot in criminal law, of course, right? You intend to commit the murder, all that kind of stuff. Contract law, we tend to judge things based upon the objective theory, as you noted, how things are manifested outwardly. But we will see sometimes where the subjective mental state is relevant. And so this is one of them, which is it's only a misrepresentation if you are lying about your intent. Here's the theory, Steve. The theory is that a promise is a representation that you intend to perform as promised. We could actually have a long discussion and philosophical debate on this. Are all promises really an indication that you intend to keep it? They may not be. You might give a promise, but everyone kind of knows that there's a really good chance you're not going to keep it. But that's getting too complicated. The theory is that when I promise you X, I'm indicating to you that I currently, in my own mind, intend to do X. And if I don't, I'm actually, by making a promise in that situation, misrepresenting my state of mind. So your state of mind in law, at least in contract law, is considered a fact. And so if I misrepresent my intent to perform as promised, that is a misrepresentation. We'll talk about this down the road with opinions. Under the restatement, you can misrepresent a statement of opinion if you don't actually believe it. So you say like, yeah, you look amazing. Most people say, well, that's an opinion. It can't be true or false. Well, fair enough. But what can be false is whether or not you actually believe the person looks amazing. Whether they're amazing or not is subjective. It's not true or false, but whether you believe it. So yeah, that is the difference. And so you want to keep that in mind, that typically, merely because somebody has made a promise, made a contract, and breached it, do not jump to the conclusion that that necessarily means that the party who breached the contract also made a misrepresentation, that they lied. It's much harder to prove that there was a misrepresentation. You have to prove that at the time of formation, at the time of making the promise, they did not intend to keep the promise. That's very hard to do. Now you might say, who cares whether you have a misrepresentation or you have a breach of the promise? But there can be different legal ramifications from one compared to the other. So there may be times in which you do want to try to prove that there was a misrepresentation, because a mere claim for breach of contract isn't really what you want. You want the benefits of a misrepresentation claim. So was I right to be, so I was right to be stern with my daughter, wasn't I?
I think so. I mean, kids today, I mean, geez.
They've got to learn the lessons,
Yeah.
So, okay. So let's get to probably the most important thing. This stuff so far is kind of like, whatever. Yeah, it's got to be manifested, not a shock. It's got to relate to future action. Okay, got it. Here's the biggie though. It's got to be a commitment. And I'm going to go back to the prior slide. So a manifestation, we've talked about that, to act or refrain from acting in a specified way. The second part of this definition, Steve, this is the biggie. Typically, if you have a fight over whether something is a promise or not, it's not whether it was manifested. It's not whether it related to future action or conduct. It relates to this last part, so made as to justify a promisee in understanding that a commitment has been made. Now, do you notice what's going on here in the second clause, Steve? Do you see the objective theory being embedded again? Not only do you see objectiveness with the manifestation part, as you pointed out, do you see objectiveness being embedded in this definition again?
Yeah, because if the promisee has that understanding, it must have hit the outside world in some way.
Exactly. And so you've got to have a promisee, right? Again, it's got to be manifested to a promisee. And that promisee, it's a promise if the promisee was justified in understanding that a commitment has been made. So you know what that means is that if the promisor did not intend to make a promise, but the promisee was justified inferring from the manifestation that the promisor is making a promise, it is a promise under law. So you can make an accidental promise under law. So be very careful about what you say. Be very careful about the promises you make.
Do you have an example of that? Because I'm sure, I like the only way I can come up with a confusing promise is like between me and my girlfriend. So do you have one that they might see in contract land?
Well, the most famous example, you're going to know the minute I say it, you're like, of course. And I don't even know if this is what you're thinking about. And you're just like setting this up.
Was this the employer one?
Which one? Oh, that one too. So Steve was a student of mine. He knows these cases. You're talking about Embry versus McKittrick, a very famous case. I was thinking Lucy v. Zemmer. They're all basically
a classic.
They're all basically the same. So a lot of what the objective theory does, this is the objective theory of contracts, which you see embedded in this definition of promise, does its work when there's a misunderstanding. If there's not a misunderstanding, the objective theory is not interested. The objective theory is brought in when there's a misunderstanding. X manifested something, made a communication, and intended it to be perceived in one way. The recipient of that communication perceived it in a way different from the way the communicator intended it to be perceived. So we have a misunderstanding. The objective theory of contracts is brought out to decide who was more reasonable. Was the recipient justified in understanding it the way they did? Or were they not justified? Was it their problem, really their fault? Were they being too weird about it and the promisor didn't do anything wrong? That's when the objective theory comes out. So examples would include, you brought up an example, famous case, Embry versus McKittrick, where this guy has a contract for employment for a year. It was in writing and it has expired. And as you may recall, he's nervous because apparently there's a season for hiring. And if he doesn't get extended soon, he needs to find another job. He can't wait. And so the boss has put him off several times apparently. And he finally storms in. This is typically what you do. This is what you do. That's what
I do it all the time.
This is your go-to process.
Yep.
Barge in. This is advice. Barge in to your boss and be like, I need to. He says, I need to know. If you don't tell me right now, if I'm extended for another year, I'm out of here. And the boss famously says, don't let that worry you. You're okay. Get back to work. And he does. And you can see this coming. Remember, contracts is about the law of broken promises. He's laid off 2 months later and he sues saying, hey, boss, you promised to employ me for another year. And boss says, I what? He's like, yeah, remember when I came? He's like, yeah, where I said, don't let that worry you. You're okay. Get back to work. He's like, yeah, you promised. Promise? That wasn't what do you mean that was you took that as a promise for another year of employment? Of course I did. And so the fight is over whether or not the boss made a promise to employ him for another year. And the question in law is not whether he intended to make a promise. The question is whether the employee was justified in taking and construing the boss's statements as a commitment to employ him for another year. And as you may recall, do you remember the result? And it's been a long time for you. And then it's a close case. I love to debate this case in class. So either way, do you remember which way this one went?
I want to say the employee won. Am I wrong?
You are right. You are correct. So the court said, and it may have been the jury and the court affirming, I can't remember, but the court held a reasonable person, or perhaps a jury, that a reasonable person would have construed that comment by the boss as an additional, as a promise to employ him for an additional year. And so let's say we believe the boss, when the boss was on the stand and swore, I did not intend to make a promise. It does not matter. If the employee, Embry, was reasonable, it did construe it that way. You got to actually construe it that way. So if the boss didn't intend and the employee didn't take it that way, the objective theory isn't brought out. There's no misunderstanding. There's no promise. But if there's a misunderstanding, then the question is, whose was the promisee's interpretation the more reasonable one? And the court said, yes, it was reasonable, because he said, if you don't extend my contract for a year, I'm out of here now. When you say that, and in response you get, don't worry about it, get back to work, a reasonable person is going to assume, well, I just told him I was going to quit if I didn't get an extension. When he tells me, don't let that worry you, you're okay, get back to work, the reasonable person would construe that as a commitment to employ him for another year. So, but if we believe the employer when he swore, that's not what I intended. I was trying to blow the guy off, right? I mean, just get out of here, leave me alone. You worry too much. That's all I intended to say was, why are you're always worrying? Everything's going to be okay. Get back to work. It doesn't matter. So he could have made, so you'd ask for an example, and you gave it, a very good one, of an unintentional promise. That boss made an unintentional promise. The other one, we'll probably talk about it in another session, the famous Lucy v. Zemmer, where the guy offers to sell his land, the Ferguson farm. He claims he's just joking. And we know that the buyer took him seriously. And the question was it reasonable to take him seriously? And the court says, yes. So that's another example where, look, if you're joking around, you need to be clear. So you can't be subtle about your jokes. The best jokes are bad for contract law for people, because the best jokes are the ones where the people they don't get it at first, perhaps, but that's a real problem, because they will construe it perhaps as being serious. And under the objective theory, the promisee is justified in taking them seriously. Have we scared them enough? That's why lawyers don't make jokes, right?
Yeah, well, I mean, I make a few bad ones, but those don't count.
They need to be, they need to be really bad and obvious that everyone understands it's a joke. But so as we see, the objective theory is back, but what must the promisee perceive the statement as? What's the most important thing about this last part? I mean, the objective theory is huge, but they have to perceive that a commitment is being made. And I think the best way to understand this idea that a promise is a commitment is to contrast it with a mere statement of intention. See, I can put an exclamation point on power. I think you can put it on PowerPoints. Again, my book, I think I only have one exclamation point. It's bad writing. You shouldn't put it in legal briefs, but I think in PowerPoints, it's a little bit more acceptable. And I see I've got must be a commitment. A mere statement of intention is insufficient. So if I said to you, well, Steve, you probably intend to do a lot of things, don't you?
I do.
Have you?
Well, I think it's funny because this is where the girlfriend comes back in. Like, I intend to marry you is a little different thing than I will marry you.
More than a little, right? Yes, exactly right. And is this going to be a recurring theme? So
well, I'm just, when we're talking about commitments here, that's where
okay.
I'm a little phobic here.
This is fine. I don't mind having this podcast be learning contract law through Steve Maxwell discussing the, I don't know how she would feel about that.
But I think it's funny. It's like, but what's interesting, at least to me, being like quasi outsider here, is the parallels, because this, like, a commitment still means a commitment in contract law. Would you say it's the same?
No, I do use that analogy a lot. I mean, I talk about when you then enter into a contract, you've got a partnership of sorts, and terminating the contract. I often talk about like divorce. So absolutely, I think you can use that analogy. And I think your analogy was a good one, which is, yeah, so, and it's not really an analogy, it's an example. So you're absolutely correct. So if you said to someone, and keep in mind, we're not talking about contract formation. All we're talking about right now is understanding the concept of a promise. And yes, how it's defined under law, which is probably a little different than a layperson idea, but we're not worrying about contract formation, legal issues. We're just talking about, is this a promise under law? And your example is a very good one. So yes, if you say, so we know, let's talk about some of the things. We can use your example to actually run through promise. So if I look, this happens in the movies a lot, right? Where I look at my girlfriend and I say to myself, I don't know how you do it in the movies, or you just kind of mumble it so she can't hear. She's across the way, right? And I'm standing alone and I look over there and I say, I promise I'm going to marry that woman, right? That's a kind of movie kind of thing. We know, yes, I've sort of manifested that. I guess I've mumbled it. So I guess I've sort of manifested it. But if you look right below, it says there must be a promisee. So if you make a promise, even if you manifest it, but there is no promisee that you are communicating this to, it's not a promise. If in my head, I said, I promise I'm going to marry, I promise myself I'm going to marry that woman, it wouldn't be a promise, both because I didn't manifest it. So I could even say, I promised her I'll marry her, but I just think it, not manifested, not a promise. I say, I promise her that I'll marry her, but I never say it, not manifested, it doesn't work. Now she comes back, she comes over, and I say to her, as you said, I said, I intend to marry you. It's kind of a strange thing to say though, Steve, isn't it? Why are you saying it? That's a weird, is it?
Because I'm a lawyer. That's exactly why.
That's right. That's right. You want to make sure you know that this video is paying a lot of dividends for the real world, not just for the bar exam. This is paying a lot of dividends. Yes, I hope you're talking to another law student or lawyer, because you may not really understand what's going on. So yes, I intend to marry you. You are, boy, you've checked off a lot of boxes, Steve, of promise, but you didn't get that last part. Yes, you manifested it. You did it outwardly. You said it, you said it to a person, to her. So there's a potential promisee. And you
the
did
way
also,
that I was going to act, something that I was going to do.
Exactly right. A statement of intention to act or refrain from acting in a specified way. So you're very close. So statements of intention and promises travel together down the road for a while, and then they hit a fork in the road. And the difference is a promise continues on and includes a statement of commitment. What a reasonable person would be justified in understanding is a commitment versus just stopping short as a mere statement of intention. And so the kind of words that you're looking for obviously are promise, of course. I promise to marry you. So this is transferred from a mere statement of intention, I intend to marry you, which is not a promise under law, to I promise to marry you, which she would now be justified in understanding that a commitment has been made because the word promise suggests commitment. Other words will work too. It's not always like it's so easy to figure it out. Context matters, but I shall marry you. I will marry you. Most of the time, unless there's something weird about the context, those words too signal, make it justified for the recipient to take it seriously that you're making a commitment. So that's the key for a promise, is that the person is making they're indicating a commitment to perform as they are indicating. And illusory promise. So this is also something that pays dividends down the road. An illusory promise is not actually a promise. I mean, hence illusory, all right, like an illusion. So an illusory promise is one where I use language that is promissory in nature, but I'm also retaining the complete discretion whether to perform or not. So boy, I hate to go back to the marriage. Oh, Steve, this is not going to be romantic at all. But so how would that go with you and your conversation with your girlfriend if you're going to make an illusory promise to marry? I'm thinking this conversation might be the end of your relationship. How would that go, do you think?
Yeah, would that be something like, I will marry you if I feel like it?
Yes.
Is that the degree of romance that it would require?
That is the perfect degree of romance. Yes, which of course is 0. That, yes. So the classic example, this often doesn't come up actually. The classic example, interestingly enough, is one that you don't see a lot because it's so ridiculous. But yes, if you promise to do something, if you feel like it, a promisee, they're not even a promisee because there's no promise, but we'll just call them a promisee. The promisee is not justified in understanding you've made a commitment. You'd be like, no, they've committed to do it if they feel like it. All right, get out of here. That's ridiculous. You know, I mean, because if they don't feel like it, they don't have to do it. And that's no commitment at all. So that is an example of an illusory promise. It's not a promise. And where that will pay dividends later is typically things where you study, say, exit clauses, termination clauses in contracts, cancellation provisions, where the contract buried deep within the contract, say, allows a party to cancel at any time for any reason. That then means all of their promises in the contract are illusory, because if they can cancel at any time for any reason, they've not actually made any commitments, because they can just be like, yeah, well, we're canceling. But that is the concept of an illusory promise. And where dividends will be paid later on things like statement of intent versus commitment or something, I know you're gonna, when you hear this phrase, you say, okay, yeah, I know about this phrase, and this is like a bar exam kind of thing. I think preliminary negotiations.
Yeah, I think that's the thing right there, right? That's the whole kit and caboodle on a bar exam, particularly. There's a lot of facts about prior to contract formation, which is kind of where we are in promise land. And as a test taker, I'm just hunting to see when these definitions are met. And I've got these definitions in my head, and I'm looking for the different the different phrases. I'm looking for where was the commitment made and whatnot. And so, yes, this is where professors like to load up the facts on pre-contracting to give us tools with which we argue both sides, because like these are really, really robust for arguing.
Indeed. So, if you see a lot of discussions going back and forth, one party might end up saying, well, I think we had a contract. And the other party says, contract, that was just preliminary negotiations. And although that's sort of the language you'll be using, you probably won't be talking about promise, but embedded within that analysis really is, did either party manifest a promise? Did they manifest an intention that this would be a commitment, or were they just stating intentions? I intend to do this. Can you say, look, I fully intend to do this deal. That doesn't sound like an offer or an acceptance to me if you're just saying you intend to do the deal. So that's where it's going to pay dividends down the road. Okay. We have three types of promises: express promises, implied in fact promises, and implied in law promises. And this is these concepts, express versus implied in law versus implied in fact, you are going to see these often throughout the course. The idea of express terms, implied in fact terms, implied in law terms. Right now they're attached to promise, but you're going to see these concepts recur throughout the class. Now, an express promise is probably what most people think of when they think of a promise. The party made it through oral or written words that are promissory in nature. So the dividing line between express promise and implied in fact promise, I think, is blurry at times. But express promise is typically where the party said, I promise to do X. I will do X. I shall do X. They said it. They wrote it. It's pretty clear. It's not like you have to do a lot of inferring from context to figure out whether they're promising. They are being pretty clear about it. Things get harder when we get to implied in fact promises. And I think this is where students sometimes struggle. They learn that a party can make a promise without making any sort of indication through words that, and I got to be careful, this is hard to do, any sort of indication, let's say with words, that they are making a promise. And let me give you the example that I use. Steve, do people still use taxis? Because I'm not sure. I mean, is it all?
Yes, some cities, I don't think the ride sharing is quite caught up.
Got it. So you jump into a cab, and I say, take me to Times Square. There's probably, like, New York probably has a lot of cabs, right? Take me to Times Square. And I'm driven to Times Square. Steve, have I promised that cabbie that I will pay him for the ride? Because I just said, take me to Times Square, and he drove off. That's all I said.
Yeah, I didn't hear any express promise there.
Right? So what do you say? Is this good advice to our listeners to jump into cabs to say, take me to Times Square, and then refuse to pay?
If they want to make it to a case book, perhaps.
A criminal law case book.
Yeah.
In addition to a contract case book, you have more contract liability, I think, is the least of your problems. And that's
right. That's right. Especially these days.
Yes, I think that it's the criminal law liability. So what do you think? As a promise, have I made it? I haven't made an express promise. Do you think it's fair to say that I made an implied in fact promise?
I think absolutely. I think, nobody walks into a cab thinking that they're going to get a free ride. That's just not a thing. I think that's a very reasonable inference from the circumstances that you go into a cab, it's labeled taxi, and you know that you're going to have to pay for that ride.
And here's the great news for the cabbies, is that, remember, whether a promise was made is based upon an objective theory. Would a reasonable person be justified? So the person who's like, what's a taxi? We're not going to have a lot of sympathy for them. So the person who, let's say we give them truth serum. Like, did you know what a taxi? And they say, I thought taxi meant free. I'm not, I don't speak the language, whatever, right? I thought taxi, I looked it up, and I guess I got it wrong because I thought taxi meant free ride. And let's say the truth serum is like, yeah, that's actually true. This is not going to save them under the objective theory, because the question is going to be, is it reasonable for the cabbie to infer that the person jumping in the back seat and saying, take me to Times Square, has promised to pay? Everyone, of course, is going to say yes. And so whether or not the person jumping in the cab actually intended to pay or intended to make a promise is irrelevant under our objective theory. So implied in fact promises are when parties make, they're real promises. They actually make a promise. But this is where students struggle, because they think that when you say actually made a promise, we're only talking about express promises. But implied in fact promises are as real as promises as express promises. They are just made in a different way. They are made through perhaps a combination of what you said and what you did, or maybe simply what you did. But they are, all of them, if they're implied in fact promises, rely upon inference from the context of what is happening. And so that is an implied in fact promise. It does, as a true promise, it does require interaction between the parties. And this is sort of something to help you maybe with multiple choice questions. You've got to have, if you don't have interaction between the parties, you don't have, because you have to have a promisee to have an actual promise that you are manifesting it to that promisee. And so if you do not, you're not manifesting something, whether it's, because manifestation means not just words, it also means things you're doing, conduct. If you're not manifesting it to a promisee, it can't be an actual promise. And so it can't even then be an implied in fact promise. But so that's implied in fact. We could probably list out a ton of interesting situations where has that person made a promise or not. Implied in law. It's about to get, is it going to get ugly now, Steve?
It's going to get very ugly. I've got an example of this one too.
Oh, you do, for the implied in law?
Yeah.
Okay, well, let's start with the definition. This definition, do you know how much help this definition is going to be? Like pretty much zero. So this definition is not going to help you understand the concept at all. A lot of understanding implied in law promises is seeing it in action. And Steve's gonna has an example in the wings waiting for us. But an implied in law promise is not an actual promise, not in the sense of that definition. So if we went back to that definition of promise, so there is no, you don't have to have a manifestation at all, actually. You don't have to manifest anything. So implied in law promise is a fictional promise that the court creates in the interest of justice. So what the court is actually doing is say, you know what? I know there was no express promise. There wasn't even an implied in fact promise here, but we are going to say a promise was made so that we can give a way for the promisee to get some recovery from the promisor. We're going to say you made a promise, and then of course you breached it. You didn't even know you'd made it. And then say you breached it, and then order compensation for you breaching that promise. And the court is going to do that when it thinks, even though an express promise wasn't made, even though an implied in fact promise wasn't made, the court thinks the just thing to do is to create a promise. And the two big situations where we're going to see it, this is very vague, but is to avoid what we call unjust enrichment. One party has received a benefit from the other party, and they never made an express, nor perhaps even an implied in fact promise to pay for it, but the court thinks it would be unjust for the promisee, for the promisor, to have received that benefit without providing compensation to the promisee. And the other big one is a contract. Almost, I think every contract is going to have gaps in it. Even maybe your big standard form contracts that are very long, there's gaps lurking, things that the parties never thought about it. And the court will have to decide, what do I do if there's a dispute and I look through the contract and I can't find any provision dealing with this situation? It's sort of a head scratcher. The parties never thought about it. What's to be done? What courts will do is they will supply a term that they think is reasonable. And that is an example of the court supplying an implied in law promise. It's the just provision to add here. The parties didn't think about it. Those tend to be the two most common ways you see courts in contract law use this concept of implied in law promise. And what's interesting about it, since it's not a real promise, it doesn't require interaction between the parties. All right, Steve, you said you got an example waiting in the wings. Shall we bring it out?
All right, here goes. I read this in the paper. It's probably about 2 years ago. It made in the paper that Best Buy had sent this guy this giant big screen TV. And the problem was the guy had never ordered a big screen TV from Best Buy. And so just one shows up, lands at his house, he takes it, he sets it up, he's enjoying the TV. Best Buy figures out, oh my gosh, this was sent to this guy by mistake. And so they contact him and he ghosts them. He's like, oh, finders keepers, it's at my house, I've got it. And of course, this was in the paper because the guy ended up getting arrested, but a criminal action. But correct me if I'm wrong, is that an implied in law promise to pay for the TV if this was a complete mistake and just got mailed to this guy?
Yes, I think absolutely. So there is a case that I used to teach where two companies each ordered steel from different suppliers, and they shared a warehouse or something like that. And you can probably see this coming. Steel arrives for party number one. Party number two mistakenly thinks it's for it. It takes the steel and resells it. I guess it was like a steel dealer, and resells it and gets the money. Well, obviously, supplier is like, probably the other party's like, where's our steel? And the supplier's like, what do you mean? Where's this? I sent you the steel. They're like, we didn't get it. And they figure out what had happened. And the question was, did the company that took the steel and resold it, did they have a legal obligation to pay the supplier? Now, everyone sort of knows there's going to be a legal obligation. I mean, it makes me insane not to. I mean, you joke about, finders keepers, these kind of ideas that lay people have that sometimes we have to spend time disabusing law students of these notions because they come with these ideas of things like finders keepers, losers weepers, and we have to disabuse them of that. Yeah, that's not law. And so everyone sort of understands that you're gonna have to pay, but the question is, what's the legal duty? Where does it come from? What is the source of law that makes them responsible? And the court held that it was an implied in-law promise to pay for the steel. Now, what's interesting about it is boy, some of these really show that tough distinction between implied in fact and implied in law. That line can be quite blurry at times. Implied in fact, we mentioned, generally requires interaction. So if you're not seeing any interaction, and you can say, well, what's interaction mean? They knew who it was, but they never communicated with them. So if you see no interaction, the safe thing, if you're debating between the two, like in that Best Buy case, I think the safe thing to do is you see no interaction, it's most likely it's going to be implied in law promise as opposed to implied in fact, because they weren't promising. That guy was doing the opposite of promising Best Buy, right? I mean, he wasn't manifesting any intention to pay Best Buy. And this is going to get a little complicated. We'll talk down the road about things like accepting offers through what we call the exercise of dominion. And so this will get a little complicated. And we'll talk more about it probably down the road. But the court held it was an implied in-law promise. They found and they made an implied in-law promise to pay for the steel because they said that the just thing to do was to require him to pay because they had taken it and sold it. And so, yes, I think in your hypothetical, well, it's not hypothetical, it's news. The guy who, if you get something by mistake and you know it's a mistake and you use it, that is a very good example of when the court is going to hold that there is an implied in-law promise to pay for it. You've taken a benefit and you've benefited from this mistake. Now, you could say that, well, wait, isn't that an implied in fact promise? This is probably a bit of a debatable issue. I teach that this is an implied in law promise. If Best Buy was not intending it to send it to this guy, there'd just been some mix up. They weren't really intending to make him an offer, right? And they probably assumed the guy, I mean, I assume Best Buy doesn't send TV sets until you paid for them. So it was just a straight up mistake. It wasn't like they were intending to make him an offer. They just totally, right. They just totally screwed up, right? I mean, I assume I could call Best Buy like, hey, I got a deal for you. You send me that TV and then I'll pay you later. I mean, I assume I can buy it on credit and stuff like that. But if they're not intending to make an offer to him, then this is just a straight up mistake. And so there's no real interaction between the parties. And yes, I think that is a very good example of what would be an implied in law promise to pay. And notice what the court's doing, because the guy's gonna be like, Hey, he's like the guy in the cab. Hey, I never promised to pay for that. And it wouldn't even be reasonable to infer I was making a promise to pay for that. Cause like, dude, I got this by mistake. So why would it be reasonable to think I'm agreeing to pay for it? They don't even know who I am. All sounds quite true. Not bad. Good work. People can be really good at arguing. You know where oftentimes law students are display amazing analytical abilities when they're like parsing the student handbook. Their interpretation ability, where have you been all semester? Right? All of a sudden they're like making these amazing legal arguments when they've got when they've got a dog in that race or whatever, so to speak.
Oh my God. Or when they're trying to get their grade changed or something, they become great orators.
It kind of reminds me when my daughter she would complain when she would argue about stuff, and she's making me so mad because she's being, but she was making these like really good logical arguments. I didn't know if I was supposed to be angry or proud. I was a little bit of both. That's why I feel sorry for these students that they're arguing over like this provision in a handbook. I'm like, I don't know, should I be upset with this, or should I be really proud that you're like taking all these skills I taught you? So yes, that guy with the Best Buy, so far so good. No express, no implied fact. I buy all of that. Give me a break. The court's going to infer as a matter of law, not as a matter of fact, but as a matter of law, imposing it upon you, whether you did it or not, or intended to do it, or would it be reasonable to infer. None of that matters. We think as a matter of justice.
I have a dumb question here.
Go for it.
Implied in law, if a student were to say a constructive promise, does that exist?
You can certainly use that. So, what's interesting about so much, it seems to me, of law is very much like being a mechanic. So I know nothing about cars, and guess how long it would take a mechanic to know I know nothing about cars? Like a second.
2 seconds.
2 seconds.
Yeah, right.
2 seconds. So I don't remember, what was it, Mr. Mom, where he's like, well, you're going to use 220 or 221 or whatever it takes. 220, yes, 221, yes. Whatever it takes. Sorry, no one watching this remembers that, right? But
but that's one of my favorites.
It's right, because he's
old people love that.
Yes, he's asked, right? So the guy asked him, he says, well, what are you going to use to wire this? 220? And he's like, 220, 221, whatever it takes. And I get the joke, I'm sure, is that there's no 221 or whatever. And so a lot of your transition as a law student to lawyer is not simply understanding the legal analysis. That's the most important thing, of course, but is also mastering terminology. And what can be very confusing about terminology in contracts, and I'm sure this is true in other areas, is that oftentimes, not only do we like you to master the terminology, we have different words that mean the same thing, but they attach to different concepts. So you said the word constructive. Constructive is the same as implied in law. Constructive means to build. The court creates. It isn't, they don't find it. Like an implied in fact or express, they find it. You said it. You acted that way. Implied in law, the court creates it. So I say it's a fictional promise. And so constructive means implied in law. They're interchangeable. But if you broke open Black's Law Dictionary, you probably find, yeah, implied in law, see constructive promise, all that stuff. We tend to use constructive sometimes and implied in law sometimes, not because using one or the other would be right or wrong, because they mean the same thing. When we talk about conditions, we'll talk about constructive conditions. We use there the word constructive, but they're implied in law conditions. And yeah, you could say implied in law conditions, but I think professors would sort of expect you to call them constructive conditions. And so I think if I was reading a paper and somebody said, well, this is a constructive promise, I wouldn't mark that as wrong, because assuming it was implied in law, because that's right. But you will see different phrases meaning the same thing used in different places. And so that, that can be tough. I would think that can be very tough on the new law student. Why do we say implied in law here and say constructive there? And when I say, it's like, I don't know. When in Rome, we do.
Right. Go with what the case law in your prof's case book says. Absolutely. Do whatever that is. That's the cheat guide right there.
That's the most important. We need a slide on that. But that is, yes, constructive means implied in law. So yes, you could say constructive promise. I think you hear implied in law more.
Yeah.
And let me give you, so your Best Buy was a great one. I think there's two great examples for implied in law promises where you're actually trying to avoid unjust enrichment. So as I mentioned, there's two big categories, the unjust enrichment cases, and then the ones where we are what we call gap filling in contracts. Because if you think about it, that's implied in law too, right? The court is constructing terms when the parties didn't think about the issue. And we'll have a podcast down the road on gap filling. But unjust enrichment, I think there's two big unjust enrichment situations. That doesn't mean there's not many more. Wherever the court finds unjust enrichment, they find unjust enrichment. But I think the two biggies are benefits provided by mistake. Your Best Buy example, I provided the steel example. The other one is, and I don't know how much this happens, the other one is the unconscious victim, the unconscious person who receives medical attention. So I am, let's say, going to the movies, I'm standing outside, I slip and fall, I hit my head, and I am unconscious. A doctor races and provides aid to me. And we're going to talk more about this in our next podcast because we're going to talk about so-called quasi-contracts. So we don't want to talk too much about this. But I'm unconscious, I get medical attention. And then the question becomes, okay, should I have to pay compensation to the doctor? Well, have I made a promise? So let's not even talk about should I have to pay compensation. The question is, have I made a promise to pay compensation? I haven't made an express promise. I was unconscious. I haven't made an implied in fact promise because remember, an implied in fact promise is an actual promise. It's just you have to infer it from the circumstances, but a reasonable person still believes that the person is intending to make it. They don't have to actually intend it. It can be an accidental promise. But a reasonable person has to believe the person is intending to make it, even if they weren't. You have to be justified in believing that. You're not justified in believing that an unconscious person is making a promise because they're unconscious. So it can't be implied in fact. If the court believes there has been enrichment and it would be unjust for the victim, me in this case, to not pay compensation to that doctor, the only way to find a way to provide compensation, presumably, at least the world of contract law, is for the court to say that we're going to infer an implied in law promise simply to do justice. And so anytime you see, remember, implied in law doesn't require interaction, implied in fact does. So if there's no interaction because somebody's unconscious, it can't be implied in fact. It must be implied in law. And that is the other example, providing a benefit to somebody who is unable to assent. Either they're unconscious or maybe your house was burning down and I saved your house or I saved your dog and you weren't at home, you weren't around. That would be an example of where the court might come in and infer an implied in law promise. And that is all. If you see anything else, that is all I have on promises. You'll see the next slide is blank. So any final thoughts on promises?
No, I think I appreciate promises a lot more than I did when I was in contracts class, for sure. Because I think at some point you fill your head with all this stuff and the promise goes away because most of us transition to offer, but that's for another podcast. But I really like this discussion because it is truly fundamental. It's a couple of words long, but they're very dense and they're very, very, very important. And so, like Dan said, parse this out, chunk it. Every part of the definition needs to mean something to you, even if it doesn't mean something to you on first glance. Dig down, get into it. It will help you get to offer and acceptance formation, all that business. It will make it much easier if you're familiar with this definition.
And more importantly, Steve, are you going to be more careful with your language after this podcast?
I promise to be more careful in the future.
And on that note, that is it for episode 2 of K Talk. Hope you enjoyed it.